Another big update for you in the Jesse Butler rape case out in Stillwater, Oklahoma. The now 18-year-old, as we know, pled no contest to multiple rape and domestic assault charges after two of his ex-girlfriends came forward with shocking accusations. But when the court unexpectedly agreed to give Butler youthful offender status, basically wiping away all prison time, the victims and their families cried foul. But now, we are hearing what the state and Butler's attorneys have to say about the allegations that the court's decision violated the law. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. Okay, before we get into this, if you're looking to eat healthy this New Year's, then nothing really hits like home cooking. That's the truth. HelloFresh, this is America's #1 meal kit. It delivers recipes that feel good and taste amazing every night of the week. So as much as I want to cook from scratch every night, I just can't. I don't have the time. But HelloFresh, which is so easy to order in just a few clicks, means I don't have to compromise my love of healthy dishes. And what I love about HelloFresh is that they bring people together with meals that are simple to make but still have that home-cooked feel. They have over 100 recipes to choose from each week. Everything from seasonal favorites to recipes that are pulled from around the globe if you want to try something new. Personally, I love the Mediterranean options. I'm always looking for something healthy. HelloFresh is really that healthier option because you know why? They now have over 35 new high-protein recipes. They're made with wholesome, hormone-free, sustainably sourced ingredients. When dinner tastes this good, nothing hits like home cooking. So go to HelloFresh.com/sidebar10FM to get 10 free meals plus, by the way, a free Zwilling knife on your third box. You know what that is? A $144 value. Offer is valid while supplies last. Free meals are applied as a discount on the first box for new subscribers only. That is HelloFresh.com/sidebar10FM. Jesse Butler just can't escape the spotlight. The high school baseball player's name, his photos, they went viral when it was discovered that he had gotten practically no punishment for crimes like rape and strangulation of girls that he was dating. And this time, what we're about to talk about, a big update regarding whether or not he's going to be back in a courtroom and whether or not his future could change. Because as I get into it, there has been a push for him to be punished or his case to be re-examined. And now the state and his attorneys have responded. A lot to get into. But remember, this is all because, and we reported this, how originally it was ordered Butler would not serve any jail time after entering a no contest plea, something that the families of his victims say they never would have agreed to. They weren't properly consulted. So now they're challenging the court's decision to grant what's known as youthful offender status. And just to let you know about the case, two of Butler's ex-girlfriends, they came forward in 2024 alleging horrifying abuse. You had one teen identified as LS who claimed that after getting ice cream, Butler drove her to a parking lot and tried to rape her in his car. According to an affidavit filed with the court, LS reported she yelled and told him no repeatedly and tried to push him off of her, but was unable to overpower him. LS reported Butler told her he was sorry for what he was about to do, but he had to do it. And then, when ostensibly taking her back to her own car, he allegedly warned, "You're not going until I'm finished." The other girl, identified as KS, claims that Butler assaulted her too. In the affidavit related to her case, an investigator detailed what she claimed happened when she was house-sitting for a family friend. Quote, Butler expressed a desire to have sexual intercourse with her at the house. KS reported she did not want to do anything at the house. Butler became angry, came up behind her, put his arm around her neck, and strangled her to unconsciousness. She could not breathe, scratched at his arms, and tried to get away, but could not free herself. KS woke up on the floor of the living room after losing consciousness. KS reported there were red marks across her neck after Butler strangled her. Approximately 15 minutes after strangling her, Butler initiated sexual intercourse with her. And KS also claimed that Butler had recorded himself choking her, and police claim that they later found those images on his phone. Now, both girls reported him to their school in September of 2024. One got an emergency protective order, but she and her family claimed that Butler violated it. He would end up facing a violation of protection order charge, along with very, very serious felony charges. There were arrest warrants that were issued in January and February of 2025. They weren't executed, by the way, for weeks. He wasn't officially arrested until March 4th. And by the way, we've shown this before, but I'll play it again. We got the body cam footage from that day, which shows the moment when investigators arrived at his home.
Okay. Okay. All right, let me know. Thank you. Hello?
Hello. Are you Jackie?
Yes, I am.
Hi, Jackie. I'm Detective Bruce with the Stillwater Police Department. We're here because we have a warrant for Jesse's arrest. I assume you know that already. Okay, is he here?
Yes.
Okay.
I told him not to answer the door till I got home. He's scared to death,
So here's what's gonna happen. Like, we're gonna take him into custody. His bond is $25,000.
Okay.
Once he gets to the jail and we get him booked in, well, I guess on the way to the jail, I guess you could contact a bondsman.
Yeah.
Or I mean, if you have 25 grand lying around, you can do that. But if you contact a bondsman, then they can post his bond and he can get right out today.
Okay.
So, and
what kind of time frame does that look like? Just out of curiosity, like midnight tonight or
no,
an hour?
Like, you can contact a bondsman and it will be like an hour and a half or something.
Candy Baker, I'm sure y'all know Candy.
So
she's the one that told me.
It's a pretty quick process.
Okay.
We just have to get him booked in.
Okay.
And then once he's booked in, and just so you know, he is a juvenile, so he won't be with any adults. He can't be housed with any adults.
Okay.
So there is a chance that he may be moved over to Payne County, but for right now, depending on how long it takes you to get with her and get bond
I'll
set
call
up,
her right back. So
then he'll probably just be at our facility at the city of Stillwater.
Okay.
And she can
Whose
come over
call
there.
is that?
It just we can only hold him for 6 hours.
Oh, okay. So if I get it done now, we're good.
Yeah.
He's not going to be moved.
No.
Okay, perfect. Okay.
Yeah, he shouldn't be. The only big holdup is if we have somebody else in the jail because we can't have them intermingle. Like if they're booking somebody and it could hold us up like maybe 15, 20 minutes, something like that. But it's not going to be a long thing generally.
Well, we're ready to obviously tell our story too.
Yeah.
Jess, it's Mom. Open the door. Give me your wallet and phone and stuff. So, your what?
They're in the car.
Well, okay, it's fine. It's not locked or anything, is it? Okay. So, can you tell him what you just told me, or?
Yeah. So we're here. We're obviously going to place you under arrest. There's a warrant for your arrest. We're going to take you to the jail. I told your mom that she can contact a bondsman, and you shouldn't be very long. But there just is a process for paperwork and stuff. But right now, you do have to come with us, and I do have to put you in handcuffs. So turn around for me. I
You know we're going to win this. It's okay.
Yeah.
I'll get you out. For me? All right. Stay silent. Rick knows about this. Candy's on this. Dad's on his way. We're coming to get you, okay? Stay strong, okay? Say your prayers.
Okay, so he's going to go right to the city of Stillwater jail, and if you'll just contact her, then she does this all the time. She knows what to do.
Yeah.
Make sure she knows Stillwater Police Department, not a county.
Stillwater Police Department on Lewis.
Yeah. Let them know that we're the ones that picked him up.
And when you say we are
Stillwater PD.
Stillwater PD.
Yeah.
Okay.
That way they don't think he went straight over and over to the county.
Awful experience for a child.
Pat you down. Spread your feet for me. Nothing in your socks.
So Butler was charged as an adult with 11 felonies. He faced up to 78 years in prison. But over the summer, after a no contest plea, the court granted him youthful offender status. So just like that, those potential 78 years vanished. Instead, he received probation, which includes counseling, community service, a social media ban, a restitution payment. If he fails, he could face a 10-year prison sentence. If he completes it, record sealed, that's it. Back in December, Rachel Bussett, an attorney for the mother of one of the victims, submitted a filing that called for a review of the victim's involvement in decision-making in this case as it progressed. It's called a verified motion to enforce victims' constitutional rights for corrective hearing and for modification of youthful offender disposition in compliance with Marsy's Law. Now, Marsy's Law is a nationwide effort to not only protect victims' privacy, but also make sure they're aware of all the steps in the legal process and their rights are considered. Bussett claims that didn't happen in the Jesse Butler case, and we're actually going to be speaking with her about the latest developments in just a moment, but basically she's arguing that her client's rights were violated because she wasn't properly consulted or heard before this controversial deal was struck. And so according to the motion, as well as the court docket, in May of 2025, Butler's attorney and the district attorney for Payne County, they appeared before a judge to set a date for a preliminary hearing in Butler's criminal case. But Bussett claims Butler's legal team implied that youthful offender status had already been granted, even though it hadn't been. And a few days later, there was an order that was filed delaying the preliminary hearing. So according to the motion, it reads, Kaye and her family did not agree to a delay of the preliminary hearing and were not advised that it would be delayed by agreement prior to the DA entering this order. The May 22nd order lacked a signature for the defendant's counsel, a signature for victim's counsel, and had no certificate of service proving service on victim's counsel or proof of mailing within 3 days. On June 12, 2025, Butler filed a second motion to certify as a youthful offender, or in the alternative, a juvenile, and request for youthful offender study and psychological evaluation. The certificate of service likewise does not show that victim's counsel was served. So they're asserting that this was basically done behind closed doors, right? There was no input from some of the people most impacted by what Butler did. And you continue from the motion. It says that same day, the court entered an order authorizing a youthful offender evaluation, struck the preliminary hearing set for June 13, 2025, and rescheduled the hearing for July 24, 2025 as a youthful offender preliminary hearing. Court's order was not signed by the DEA, defendant's attorney, or the victim's attorney. There was no certificate of service or mailing of the judgment attached to the order. And on the face of the order, it is unclear who prepared the order. So it's kind of strange, right, that sort of information may be missing here. And then it goes on to say, Kaye was having surgery for a broken leg on June 12th, and she and her family had no idea such an order was being entered. On July 23rd, 2025, Kaye had a meeting with the district attorney in preparation for the July 24th hearing. Kaye was a minor and did not have a parent present or her attorney present. Kaye was told they weren't going to practice because there was a plea deal. The DA told Kaye not to tell her mother. Around 12 p.m., the DA called Kaye's mother and advised her that she had agreed to a plea deal where Butler would plead guilty and serve time in a juvenile facility in exchange for a youthful offender sentence. The family was not provided any other specifics of the deal for the YO certification. The district attorney did not advise or confer with Kaye, her parents, or the LS family before entering into plea negotiations or agreeing to the plea deal or the YO certification. So according to Bussett, the family's understanding was that Butler was going to get some sort of jail time, even if it was just a juvenile facility, but that didn't really happen. It says, quote, on August 22nd, 2025, the DA advised Kaye and her family and LS family that there was no guilty plea. The DA further advised that Butler's attorney had stated he was never going to advise his client to plead guilty. This directly contradicted what they were previously told about why the DA agreed to the YO certification. Kaye and her parents expressly objected and did not consent to any plea that did not include imprisonment. The DA told Ellis's family that they could start all over at the beginning. The district attorney stated she would continue plea negotiations and follow up with them over the weekend. The DA stated to Kaye's mother, Yvonne Sweeney, that we're supposed to include the families in discussions about these things. Sometimes that is a mistake. Kaye and her mother understood this to mean the state thought including the family in the decision was a mistake. Now, Kaye's mother gave a victim impact statement in court, objected to the case's outcome. Butler was able to plead no contest, so no allocution, no admission of guilt, got no jail time. And even now, there are issues apparently with the protective order forbidding Butler from having contact with at least one of the victims, because according to Bussett's motion, the victim had been informed that extending the protective order could be incorporated into the plea agreement, but this was not done. Victim and her family had to use the assistance of other counsel to extend the protective order. The protective order remains sealed, making it difficult to enforce the protective order because of its confidentiality, even though the DA promised this would be addressed. So Bussett argued that Butler's crimes amounted to much more than just a simple childhood mistake. The defendant's conduct was not a single youthful indiscretion, but a pattern of escalating violence over approximately 11 separate incidents during a 7 to 8 month period. And the motion concludes by saying the victim now moves this court to enforce Marsy's law and set aside the plea agreement and reset this matter as an adult prosecution and move forward as an adult prosecution, or alternatively, if the court determines that it should remain a YO, to require the defendant to allocate. Now, with all that in mind, the state, as well as Butler's attorneys, have responded to Bussett's motion. That's what we're going to talk about. All right, so to talk about all this, to get reaction to these developments, I want to welcome back on Rachel Bussett. Rachel actually just came from court, so thank you for being so generous with your time to come do this in your car, nonetheless. Really appreciate it. Okay, so it's been a few weeks since we last spoke. Before we get into the latest developments, just how are the families doing at this point? What can you tell us?
Everybody's struggling. It's really rough to see what was said in the responsive motions, but at the same time, it wasn't I wasn't surprised based upon what it's what I expected it to be. People aren't used to doing this for a living, don't understand how these things happen, and it feels very personal. So that's rough.
That's totally understandable. Now, the local news outlet, News 9, did offer some insight into what these filings are. So according to News 9, Butler's defense is claiming that Marsy's law is being, misused in this instance, that changing the outcome would violate his due process rights. I mean, Rachel, correct me if I'm wrong, but that seems to be one of the main arguments. What would be your reaction to that?
It is not an unexpected argument. I understand where he's coming from. I disagree with that, and we'll be addressing it in our response. Our position is that this plea was void, and if the plea is void, it's void ab initio, meaning from the beginning, so there would not be a violation of his rights because it wasn't done properly from the get-go.
News 9 reports that as part of its arguments, the state says that while Marsy's law does give victims a voice in the legal process, it doesn't give them control over the outcome of a case or sentencing, that it's up to the prosecution. And the response notes that the law doesn't give victims the ability to overturn or undo lawful sentences. Your reaction to that?
Marsy's law alone does not allow a challenge to what has happened. If there are other irregularities that violate the law, then it can be challenged. And so our argument has been from the beginning that this plea was improper. It was not done properly. And that is the basis for the challenge. Marsy's law is not the sole or only basis for the challenge.
So would you also be saying that it's improper for them to suggest that it was a lawful conclusion, that it was a lawful sentence? Or are you saying that the way this happened was illegal and perhaps, like you said, it's invalid?
I think you get into the technicalities of what constitutes a lawful plea versus invalidity. And I don't know that we have time to parse all of that. But basically, my position is that the procedure was not properly followed by not following step by step the process of the juvenile youthful offender certification. The certification is improper. Therefore, the plea and imposition of sentencing is improper and thus void. And something that is void ab initio is never valid and can't ripen into a valid plea.
Where is this going to end up? In other words, you will file, I imagine, a response, right, to this. Is this going to be a hearing or witnesses going to be called? What do you expect this is going to morph into?
Currently, we have a court date set February 3rd to have a hearing about having a hearing and defining what all of that looks like. Jesse, to the best of my knowledge, this is really an issue of first impression that I doubt will be resolved in the courts in Stillwater. I anticipate this will go to the Oklahoma Court of Criminal Appeals, and there might be questions of constitutional law that actually have to go over to the Oklahoma Supreme Court about the interaction between Marsy's law and criminal defendants' rights and how that works out. Either way, I see this as a case-making law.
And I want to get your take on something else that happened too, but before I do that, just so our audience is clear, is there any possibility, any outcome where Jesse Butler could be resentenced and face prison time?
I believe that it's a possibility. We're going to see whether the courts agree with me or not.
I want to get your take on this civil lawsuit that was apparently filed by the family of one of the victims, so the Selvies. This is against multiple defendants, including the Butlers, the city, the school district, the principal, the school resource officer that was assigned to the school. And this federal lawsuit that was filed in December says that Jesse Butler was known to be aggressive, violent, claims that his parents knew about it, didn't get him any sort of help. The lawsuit also accuses the school district of failing to investigate, notify staff about what was going on, take any action to protect her once LS reported the abuse. And the girl's mother filed for an emergency protective order, which was reportedly served on Butler while he was at school. And after that, the family claims the principal, Walter Howell, called her to request that she report problems directly to him instead of going to the police. And the filing claims that Howell said he chose not to enter the emergency protective order into the school's database because he, quote, did not want to interfere with Butler's opportunity to receive an education. Rachel, what's your reaction to that?
We'll be filing a similar lawsuit with similar allegations on behalf of KS and her family just as soon as the tort claim process expires and we move forward.
Yeah, we checked the federal docket for this case. It shows that the defendants have all received a summons, so it requires them to answer the lawsuit within weeks of receiving it. We haven't seen any answers have been filed. Is there anything that you can shed light on about this case, or what you think the conclusion might be here?
I anticipate the defendants will file a motion to dismiss. That will be briefed. Based upon the way our court system is moving in Oklahoma, it could be anywhere from 4 months to several years before that is decided. So there's not going to be any expeditious resolution of this issue in federal court. Whether there's separate resolution, I can't say, but we will be pursuing a similar lawsuit. Whether they're consolidated or not, I don't know that. I would expect they would be at least in discovery.
Now, Rachel, you've been getting attention. The family's been getting attention as a result of these challenges. Have you been receiving, what's been the response that you've been getting? I mean, support, those been, saying you shouldn't be doing this. There are those who are supporting you doing it. Anything you could tell us since we last spoke?
Sure. By and large, the community and individuals within the legal community and the greater community have been very supportive. Nobody likes what has happened here. I understand the district attorney has discretion and a defense attorney has a job to do. But part of our job as attorneys is to make sure from beginning to end that the process is followed appropriately and lawfully. And I don't believe that happened. And I think a lot of people question about whether or not that happened. And my goal is to make sure that we determine whether that did or did not happen. And I think there's a lot of support for that. And that's what we've seen. There's always going to be people who are going to allege that this was consensual, as suggested by the district attorney, which is absolutely not true. And there's always going to be people that support the defendant. But by and large, the community as a whole support these victims and what we're doing.
Rachel Bussett, thank you so much for taking the time. Appreciate it.
Thank you.
And that's all we have for you right now here on Sidebar. Everybody, please subscribe on Apple Podcasts, Spotify, YouTube, wherever you get your podcasts. You can also check us out on Peacock. We're on there as well. If you want to follow me, you can check me out on X, Instagram. Also, I got my News Nation show, Jesse Weber Live. Until next time, I'm Jesse Weber.